is a motion to revoke is going to be filed and you're looking at a year in the Bear County Jail. That's where we are. So there's going to be 1 year in the Bear County Jail, suspended and probated for 2 years. There's an affirmative finding of family violence. Court is calling 2024 CR 0362, State of Texas versus Nathan Bates. Could I have parties approach and announce for the record for the state?
Second for the state.
Defense.
Renee Munoz on behalf of Nathan Bates.
And are you Nathan Bates? Counsel, have you received all the discovery? Did you review it with your client?
Yes, Your Honor, that's correct.
Court will find that the state is in compliance with discovery. Mr. Bates, did you review the document entitled Application for Deferred Adjudication or Community Supervision with your attorney? Did you understand it?
Yes, Your Honor.
Did you review the document entitled True Bill of Indictment with your attorney? Did you understand it?
Sure.
Counsel, do you waive the reading of the indictment?
Yes, Judge.
State, are you proceeding on the indictment as presented?
Your Honor, the state is proceeding on the lesser included assault bodily injury offense.
Any objection?
No objection from the defense.
All right, did you review the document entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes.
Did you understand the state is proceeding on the lesser included offense of assault, bodily injury, family violence? That's a Class A misdemeanor. Range of punishment is up to $4,000 fine and up to 1 year in the Bear County Jail. Did you understand? If you have a plea with the state, court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand? Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent? Did you understand by entering this plea, you were giving up those rights?
Yes.
And did you intend to give up those rights and enter into a plea in this case? Counsel, is your client applying for deferred adjudication or no?
I believe it'll be straight probation, Your Honor.
All right. All right. Do you counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
In my opinion, he does.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Bates, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No.
Anyone promised you anything other than the plea? Satisfied with the way you've been represented? Are you a U.S. citizen? Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes.
According to the plea, the state is proceeding on the lesser included offense. Punishment is to be assessed at 1 year in the Bear County Jail. State is recommending community supervision. There's an affirmative finding of family violence. There's to be a mental health evaluation. Did you understand with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition?
Yes, ma'am.
Did you understand with an affirmative finding of family violence, you're not allowed to be designated as primary custodial parent?
Elaborate?
All right, you wanted your attorney to explain it to you?
No.
He does not have children, Your Honor.
All right, but here's the thing. If you have children, all things being equal, I'm not your civil attorney, but if you were to have children and there were a custody issue, this affirmative finding of family violence moniker is not going to serve you well in a custody hearing. You understand? Knowing that, do you still wish to continue with this plea?
Yes.
All right. Did you review the document entitled Waiver of Appeal paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counsel, have there been any such motions?
No, Judge.
And counsel, that's your understanding of the plea bargain
That
agreement?
is correct, Your Honor.
And state, is that your understanding of the plea bargain
Yes,
agreement? All right, outside the agreement, the state is requesting 2 years community supervision, no harmful or injurious contact with Danny Ray Bates. Did you understand those are recommendations from the state and the court does not have to follow those recommendations? To the offense as charged, how do you plead? I'm sorry, the lesser included offense, how do you plead? Guilty, not guilty, or no contest? State any evidence?
Yes, Your Honor. State offers states 1 and attachments.
No objection.
All right, state, before you are excused, did you speak with the complainant?
We have spoken with the complainant multiple times, Your Honor. Yes.
All right, thank you.
Thank you, Judge.
All right, did you review the document entitled waiver and consent to stipulation of testimony and stipulations with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, court will find there is sufficient evidence to find you guilty. The court will find you guilty. Are you proceeding with sentencing?
If we may, Your Honor, yes.
All right, anything you wish to say on behalf of your client?
Yes, Judge, we respectfully request that you follow the plea bargain agreement. I know that a mental health evaluation was ordered. He has been recently evaluated by Center for Healthcare Services
Mhm.
and had been maintaining appointments with them, Judge. So we ask respectfully if that could be done out of custody. We're also requesting the no harmful injuries contact. It's my understanding that the state has been in contact with the father and he's requesting the same. He is elderly and he does rely upon son and family for support as he's getting elderly, Judge. Doesn't have a lengthy criminal history, but I believe that he shows a lot of promise and that he can successfully comply with these terms, Judge.
All right, so who is taking care of his father?
He's taking care of himself, but as he gets older, he fears because of his family and my family, besides dying out.
Well, no, are there any other siblings? Are there any aunts or uncles?
No.
So you're saying in all of this world, it's just you and your father and there are no other relatives?
I have relatives, he doesn't. He's by himself. And he's been contacting the relatives I stay with, which if you check the mental place I've been going to, it's more chaotic where I'm at. And my dad's been contacting them and
He's been abiding by the no
I've been
contact
abiding
order, Your Honor. He's been staying with an aunt, so he's been respectful of the court's
with
bond conditions.
the family is, how to say, dysfunctional.
All right, here's the thing. I understand that, but here's my concern. This is not the first time that this has happened. From what I've read in the police report, it's the first time charges have been brought. So until you show me,
In my opinion, people cry wolf all the time on the phone call.
oh, well, so the bruises on your father, those are just made up?
About me, on my self-defense case that I've been trying to prove.
So-
Okay, yeah,
so-
there's gonna be no contact. Oh, yeah, I am. Let me just tell you right now, I'm ordering no contact. If you have contact with your father, what's going to end up happening is a motion to revoke is going to be filed and you're looking at a year in the Bear County Jail. That's where we are. So there's going to be 1 year in the Bear County Jail, suspended and probated for 2 years. There's an affirmative finding of family violence. There's going to be a referral to Center for Healthcare Services. Probation, we'll do the mental health evaluation out of custody because I realize it takes a long time to do that. There is going to be no contact with Danny Ray Bates. There's going to be proof of employment within 30 days. There's to be no employment as a home health care provider or with minors. There's to be regular reporting by Zoom or in person. Field visits 1 time per month until further notice. There's going to be anger management. And do the live domestic violence panel. Probation, is there anything else? Yes. We'll do regular random UAs. Is there anything else? Anything else you need from the court? All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and did you sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to your attorney. Off the record, here's the thing. Your father is elderly. Yes, people age and they need help sometimes, but I know that an elderly person would rather not be helped if they're going to end up getting hit on by their son. That's supposed to be your father. You're supposed to love him. If you don't love him, then cut him loose. If you think he was a horrible father growing up, cut him loose. But you do not fight with an elderly person, because guess what? Your age against an elderly person, the elderly person is going to lose. And it just should not be done. If you respect your father, as though you're telling me you do, then you shouldn't put your hands on him, period.
Military training beat mines.
Your Honor, if he's shown to do well.
Oh, I'm sorry, wait a minute. What did you say?
His military training beat me, so I was still pleading self-defense.
Yeah.
Your Honor, if he's shown, and he's just, is an emotional day for him, he had an active warrant, he wasn't expecting, he was a little afraid of going into custody.
Mhm.
So we appreciate the court allowing him to do the mental health evaluation out of custody. But if he's on probation, if he's shown compliance with probation, would the court be okay with me approaching an appropriate time to reconsider the chance of changing the no contact to no harm from injuries contact?
Yes.
Thank you, Your Honor.
Mr. Munoz, you're such a great attorney. You always like bring it down and you're very pleasant. I really do appreciate that.
Thank you, Your Honor. I appreciate that.
And very knowledgeable as well. Court is calling 2024 CR 0443, State of Texas versus Marcelo Flores. Can I have parties announced for the record for the state?
Daniel, for the state of Texas.
Defense.
Renee Munoz on behalf of Marcelo Flores.
And are you Mr. Flores?
Yes.
All right, and probation, this is an application. Counsel, have you received all the discovery? Did you review it with your client?
Yes, Your Honor, and I have.
Court will find that the state is in compliance with discovery. Mr. Flores, did you review the document entitled True Bill of Indictment with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
Yes, Judge.
State, are you proceeding on the indictment as presented?
Your Honor, we're sitting on count 2 and waiving count 1.
Any objection?
No objection from the defense.
Mr. Flores, did you review the document entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Did you understand in count 2, you're charged with the offense of possession of a controlled substance, penalty group 1, 4 to 200 grams. That's a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. Did you understand?
Yes, Your Honor.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, Your Honor.
Did you understand by entering this plea, you were giving up those rights?
Yes, Your Honor.
And did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
Counsel, is your client applying for deferred adjudication or regular?
It would be for a regular community supervision, Your Honor.
All right, did you review the document entitled Application for Community Supervision with your attorney? Did you understand it and did you sign it?
Yes, Your Honor.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, Your Honor.
Did you understand by entering this agreement, you were giving up those rights?
Yes, Your Honor.
And did you intend to give up those rights and enter into a plea today?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
That's correct.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Flores, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the document entitled? I'm sorry, that's okay. Did you review the plea bargain page with your attorneys? Did you understand it?
Yes, Your Honor.
According to the plea, state is proceeding on count two. Punishment is to be assessed at a cap of 6 years in the prison. The state is silent on your application. They're taking into consideration 2024 CR 0444 and 2024 CR 0445. Did you understand that to be the plea?
Yes.
Defense?
Yes.
State?
Yes, Judge.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes.
Did you understand by citing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, have there been any such motions?
No, Judge.
Then to count two, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence.
State officer exhibit one and all attachments.
No objection from the defense.
Did you review the document entitled waiver and consent to stipulation of testimony and stipulations with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits one and attachments, and the court will review the same. All right, after reviewing states exhibits one and attachments, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty. All right, I've been given a PSI date of July 9th, but really the only thing I need is a TAP evaluation and his criminal history. Probation, how long would it take to get a TAP evaluation in custody?
Your Honor, if I may, I did in advance of this court setting, reach out to PICU, and they did have a SUD clinician, substance use disorder clinician, meet with my client, Mr. Marcelo Flores. They deemed him eligible for services at Lifetime Recovery. And they just requested, if the court were to see fit to send him there, that we keep them informed of the release plan, Judge. So, in the essence of being more efficient, it seems like he has been seen, Judge, and I do have the email correspondence.
All right, then we'll still do the TAP evaluation, but it won't have to be maybe the 3 weeks in custody. If I decide to place him
Okay.
on probation, he'll be released to go to Lifetime Recovery, and probation could perhaps do that outside of custody.
Okay.
So then with regards to criminal history. Renee.
Yes, no problem. I like to have my ducks in a row as much as possible. Makes it easy for.
What's your criminal history?
Like,
Have you been to prison before?
yes,
For what?
authorized uses and, drugs.
Okay.
And the NCICT says you should be right behind that judge.
All right, thank you.
And just for the record, the state did hand over the defendant's case file that does include his criminal history in the NCICT CIC.
All right, thank
Correct,
you.
yes.
To the court reporter, were you able to pick up what Daniel said?
Sorry, I said it kind of low.
Here you are. Thank you, counsel. All right, if y'all prepare for sentencing, I'll do sentencing now.
Yes, Your Honor, we're able to. We greatly appreciate it. May I be heard on behalf of my client?
Yes.
Ever since I got my client's case, Your Honor, some red flags did go up for me. I did see that he was homeless, and he has some drug offenses that he's dealing with. I don't think that, they're independent of each other. I think that, they're related. He has been obviously to prison in the past before, but it seems like his prison stays did not have anything to do with violence, but more so were symptoms of his drug usage. So that prompted me to speak with him about his options. He's adamant that he wants the chance at drug treatment to break the cycle of his incarceration, to be hopefully a contributing member to society one day. He is understanding that if this honorable court does grant him probation and sees it fit to order to lifetime, he would have to remain at that facility and abide by all program requirements and conditions, as well as work the aftercare program. And hopefully they can help set him up with housing as well, Your Honor, to get him back on the right track. It's my fear if he just becomes a product of the institutional division, he won't be getting the same amount of services and care that he could be with lifetime recovery. So we're requesting that this honorable court order that respectfully, to hopefully break this cycle of incarceration that has surrounded his life leading up to this point.
All right, do you have any family support?
Yes, ma'am.
Who?
I have my kids, mom.
All right, how old are your children?
They're 18, 17, and 15.
All right,
And I have two grandkids.
all right. So state, I'm gonna grant his application for probation. Do either of you have a suggestion on length of term?
Judge, the state would at least ask for 6 years.
6 years, we'd be agreeable with that, Your Honor.
All right, the court is gonna find you guilty, sentence you to 6 years in the prison, suspended and probated for 6 years. Take in consideration 2024 CR 0444, 2024 CR 0445. I'm gonna want a referral to felony drug court. He's gonna remain in custody. And counsel, if you want to coordinate with felony drug court, if they accept him, they'll probably accept him and then send him to lifetime recovery. But I definitely want him to get to lifetime recovery.
Okay, Your Honor. And if the referral to felony drug court goes out and at the right capacity or something of this sort, should I bring it to the court's attention or?
No, if they're at capacity, he'll still be going to lifetime recovery and they'll probably put him on a wait list.
Okay, great.
All right, so guilty, 6 years in the prison, suspended and probated for 6 years. I'm taking the cases into consideration that the court has previously stated. He's to remain in custody until he has a felony drug court evaluation and a transfer to lifetime recovery. There's going to be regular reporting by Zoom or in person. The UA hotline until further notice. And counsel, usually I keep the UA hotline on until he's actually been in treatment for a while.
Yes, sir.
Proof of employment within 45 days of release. There's to be no employment as a home health care provider or with minors. There's to be no unsupervised contact with minors until further notice. So that means you're not allowed to babysit or do any of that. Do you understand? I'm gonna want field visits. One time per month for 6 months. There's gonna be 300 hours of community service restitution. I'm gonna order parenting classes. Once he completes the parenting classes, the community service hours will be deemed satisfied. There's to be regular reporting by Zoom or in person. There's gonna be 120 sober meetings in 120 days. Probation, is there anything else that's needed?
No, Judge.
Is there anything else you need from the court to be successful?
Since lifetime recovery.
All right, I'm gonna show you what's entitled trial court certification of defendant's rights to appeal. Did you review that document with your attorney? Did you understand it? And did you sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you need to speak to an attorney. Do you understand?
Yes, Your Honor.
All right, so off the record, here's the thing. Maybe you came in, maybe you thought you're gonna end up going to prison, but you're not. So you need to remember where you are now and what you were thinking and what you've received. In this court, to be successful on probation, communication is key. If there's an issue, let probation know. If you feel you're gonna use, call the sponsor. If you're in felony drug court and you feel you're gonna use, let them know. Don't get on this train where I used, I'm not gonna report, because then it's just all, you understand?
Yes.
All right, good luck to you, okay?
Thank you, Your Honor.
You're welcome. All right, court is calling 2021 CR 6023, State of Texas versus Israel Mankata. Could I have the parties announced for the record for the state?
Jason Garrett.
Defense?
George Schaefer for probation or defendant. Your Honor.
And are you Mr. Mankata?
Yes.
All right. We are here, your attorney is, because there's a warrant out for you, your attorney is asking the court to set a bond. And state you have no objection to the motion being oral?
No.
All right, defense?
Judge, to the extent that he's on a deferred adjudication, obviously a bond is allowed by the Code of Criminal
Yes.
Procedure. We would ask for a bond amount similar to what he had when he got this offense in the first place, which is $10,000. I want to note two things for the court. One, he has brought himself in and surrendered himself, which is a good thing for him to do. Secondly, the other nice thing for me is he has hired me to represent him on this matter, and I will do so vigorously. We would like to get him bonded out of jail so he can continue working and taking care of his 10-month-old baby.
Okay, all right. And so that the record can be clear, I'm aware of the defendant's previous criminal history because he is on deferred adjudication out of this court.
Right.
So I'm aware of some issues that he's had in the past as far as with alcohol. So are there any mental health issues that the court needs to be aware of?
No, Your Honor, not that I'm aware of.
All right, can you raise your right hand for me, please?
Yes.
Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
It's fine.
All right, you can lower your hand, state your name for the record.
No,
All right, so is there any mental health issues with you?
no.
All right, other than alcohol, which that's something that's related to the charge that he's on for out of this court.
Right.
Other than alcohol use, are there any other drug uses issues?
No, just the day of, I used the THC because I was going through depression, because I hadn't been able.
Oh,
to
no,
do
no,
my
no.
fun-
Here's the thing. I don't want to talk to you about
Okay.
the reason for the motion to revoke
Yeah, like
because,
you. Just the day of, I was around someone that was smoking.
all right, so
And,
let's not do around someone.
Okay,
So
yes.
what, this is what I'm trying to figure out. One, I don't want to have you respond without conferring with your attorney to anything that has to do with the case. Because I'm just here for your motion to revoke. You're on deferred adjudication, so you're legally, you must receive a bond because it's deferred adjudication. Technically, it's not a conviction. So I'm just trying to figure out what conditions of bond to set for you so that you'll be successful on bond. The motion to revoke, that's something that will be addressed at a different date. So we have previously, when you're on bond with this, for this case, there were issues of alcohol. So I'm just specifically talking about this case, not anything else. So we have alcohol issues. Do we have issues with marijuana? And by issues with marijuana, I mean you've used marijuana before.
Yeah.
Okay, so we have the marijuana issues. All right. And no mental health issues ever been diagnosed? All right. So, defense, what bond amount are you requesting?
Judge, I would request a bond similar to what he had originally. I think $10,000 will ensure his appearance at any court proceedings. I think this young man understands he was in a bad position, made a mistake, and is ready to accept the responsibility going forward.
Yes, sir.
All right, so I have reviewed the motion to revoke, so I can see if there is any allegations of you not reporting or any issues with that. All right, state, what are you asking for bond?
State's not opposed to $10,000 bond, Your Honor. That was what was previously instead, at the beginning of his, abatement case.
All right, so I'm going to set bond at $10,000. What I'm going to require in probation, we're not addressing his motion to revoke, but is he able to receive alcohol treatment still with you all, even though he has a pending motion to revoke? All right. So then what's going to end up happening is you're going to have to do some sober meetings. And whatever depression you were going through at the time of the alleged new offense, are you seeing some therapist or somebody to address those issues or no?
No.
All right. Counsel, do you know of some place he can go, someone he can talk to? I know he can talk to people at the sobriety meetings and that's confidential, but do you think he needs something other than that?
No, Judge, I believe also the DWI is going to take care of the alcohol rehab and the classes that are attending to it.
Okay. Do you have insurance?
No, ma'am.
All right, I'm just gonna tell him, you need to go and see someone at the Center for Healthcare Services, just somebody to talk to. You may always say it's great to talk to somebody, and especially sometimes it's best when you can talk to a stranger and you can just let loose, all right? So I'm gonna ask for a referral. Well, technically not a referral. I'm gonna require you to go to Center for Healthcare Services. All right, is there anything else that he needs? And I think the Center for Healthcare Services will probably help you with your probation.
First row.
All right, so
Start taking room.
it's an evading case, so it's not a violent case, so they may be able to do a walkthrough. I'm not sure. Deputy Laura,
There's 3 more people coming.
Oh, okay.
Move over.
and then we need a setting for this motion to revoke.
Right.
What date are you looking at, counsel? And is it going to be contested, you think, or no?
No, Your Honor, it's not. I know that his DWI is set on the 17th of July, I believe.
All right, and I don't know if they've ordered it, but I'm gonna order no driving as a part of his.
Conditions.
Yes. All right. And so then you say it's set for July 17th?
Yes, Your Honor.
Do we need it on July 17th or are you all allowed to do anything with DWIs as a part of this or no?
Well, I mean, it's a misdemeanor, Judge, so I mean, we could always do something on our case. And then they could, I mean, I don't know what, you haven't worked the case out yet.
I haven't even seen discovery on it yet.
Yeah.
I
so I
think
don't-
after they get discovery, and we could
Then
definitely,
we can talk.
we could definitely talk here and resolve this, and then they could go resolve it there also.
All right, so
After.
it's just that I don't want to keep him out in the wind for more than a month. And you're saying July 17th?
That's when the DWI is set, but if you want to set this sooner, fine by me.
Yeah.
You said it like in 30 days, Judge. I think we could possibly work something out here, and then I can tell the misdemeanors to follow that.
All right, so what I can do is I'll recall it for June 25th.
Yes, Your Honor.
And probation, he's gonna be reset for June 25th, but you're gonna need to report to probation. Is there any way to do that or no?
Once he gets out.
Yes, Judge.
All right, so you're gonna be reset for this case for June 25th, but you need to make sure you report to probation. I'm gonna give you the reset form. Once you sign it, Deputy Laura and Deputy Mejia will do what they do.
Thank you, Your Honor.
You're welcome. Let me give you the reset form. All right, court is calling 2024 CR 4975. State of Texas versus Jorge Luis Juarez Jimenez. Can I have parties announced for the record for the state?
Jason Garrett,
Defense?
Richard Garcia for the defense, ready, Your Honor?
All right, and we have a interpreter here. Could you raise your right hand for me, please? Do you solemnly swear and affirm you will faithfully translate from English into Spanish and Spanish into English, so help you God?
I do, Your Honor.
And you can lower your hand. Could you state your name for the record?
Norma Nido.
All right. So, Mr. Garcia, do you speak fluent Spanish?
I do, Your Honor. In fact, I'm a Mexican citizen as well.
dual
I'm
citizenship?
dual citizen.
Okay. And were you able to explain these documents to your client in Spanish?
Yes, I was, Judge. Or I did.
Mr. Jimenez, all of the documents I'm going to review with you are in English. Were those documents explained to you in Spanish? Yes. Counsel, have you received all the discovery? Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Jimenez, did you review the document entitled True Bill of Indictment with your attorney? Did you understand it? Yes. Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, we are, Your Honor.
Did you review the document entitled Court Admonishments and Defendant's Waivers and Affidavit of Admonitions with your attorney? Did you understand it? Yes. And did you sign it in all the appropriate places? Yes. Did you understand you're charged with failure to stop and render aid in a moving vehicle? That is a hybrid felony. The range of punishment is up to a $5,000 fine and also 1 year in the Bear County Jail or 2 to 5 years in the prison. Did you understand? Yeah. If you have a plea with the state, court does not have to follow your plea. If for any reason the court doesn't follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand? Yes. Did you understand you have a right to jury trial? A right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. Yes. Did you understand by entering this plea, you were giving up those rights? Yes. And did you intend to give up those rights and enter into a plea in this case? Yes. Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Jimenez, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea? No. Has anyone promised you anything other than the plea? No. Are you a U.S. citizen? No. Counsel, have you discussed with your client the impact this case will have on his immigration status?
I have, Your Honor, and I've consulted with Justin Tullius of the MAC and Jorge entered the US illegally. He has no legal right to be in the United States. And he understands that he will be deported and he will be barred for 10 years for readmitting himself into the United States or applying for readmission to the United States.
All right. Mr. Jimenez, did you have an ample time to speak to an immigration attorney? Yes. And do you understand the impact this plea will have on your immigration status? Yes. Do you understand by entering a plea in this case could result in your deportation from the United States? Yes. The denial of naturalization? Yes. And the barment of reentry. Did you understand? Yeah. Knowing that, do you still wish to enter into this plea? Yes. All right. Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it? Yeah. According to the plea bargain agreement, defendant is to be sentenced to 2 years in the prison. There are no applications and there's to be restitution to Nally, Nalley, Carolina Rodriguez. Did you understand that to be the plea?
Yes.
Defense,
Yes, Your Honor.
state?
It is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counsel, have there been any such motions?
No, Your Honor, there has.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
Guilty.
State any evidence.
Yes, Your Honor. State exhibit number 1 with all this attachment.
Any objection?
No objections, Your Honor.
And state before you're excused to continue conferring. Have you had contact with the complainant? All right, thank you. All right, and so the record can be clear. In the police report, the complainant's name is also spelled Nallely. You want me to repeat it? All right.
Yes.
Nallely.
Yes.
All right. Did you review the waiver and consent to stipulation of testimony and stipulations with your attorney? Did you sign it in all the appropriate places?
Yes.
Again, did you understand you have a right to a jury trial? A right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. The court has reviewed the same. The court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, we were asking that you waive the PSI and sentencing today.
Anything you wish to say on behalf of your client?
We're asking that you follow the plea bargain, Judge. He is a resident of Mexico, or a citizen of Mexico, rather. And he understands that he did wrong, and he wanted to take responsibility, but he's been locked up for 3 months. And so he hasn't been able to.
All right, then the court will find you guilty. The court will sentence you to 2 years in the prison, give you credit for any time served. There's restitution, if any, to Nally, Carolina Rodriguez, and you're barred from re-entry. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it? And did you sign it?
Yes.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes.
All right, good luck to you.